Welcome back to Morning Live, and right now you want to touch base on matters inheritance and willingness, because now this has been a tug of war for quite some time from even our leaders. You know very well, handing over power has been a problem in Africa, but now we want to focus on inheritance and of course how parents can actually make a smooth transition to their kids, and for this purpose is to avoid all the tug of war that goes around in case now they leave this earth. And in the studio I'm joined by Kebaso Morara, who will now be elaborating more on how these things should be done, because now willingness is a recipe to make sure there's peace all over. Karibu sana Bwana Kebaso.
Thank you.
All right. Now, when you talk about inheritance, this is something that has been in our African society for quite some time. And in simple words, you're taking over. Or maybe in that matter, I will now give this to person X or Y. Now, why has it been so difficult for some quarters, in fact, families especially, to embrace the inheritance procedures?
I think inheritance is a very important thing in the community that we have today, and also considering that we now have a capitalist society which recognizes the individual ownership of property. It is important that this property is passed on to someone. And it is it is something that has been there for ages.
Okay.
However, as you've correctly pointed out, we have a problem with the procedure of passing on property from the parent to the surviving children or spouse or other relatives. And the reason we have this problem is, one, because people are not well informed about the procedures of inheritance and what it is that they need to do so as to ensure that succession of their property is smooth. Because wherever property is involved, there is conflict because there is interest. So there is the expectation that at least if succession is to be smooth, there has to be a will. And most people these days are beginning to make their wills before they pass on.
Sure.
Though in the African society, people tend to think that by making a will, you're predicting your death.
Yeah, yeah.
But making a will,
scary.
which is very scary.
Very scary, yeah.
But making a will is a very important part of succession.
Okay.
From a lawyer's point of view, there are two kinds of succession. There is tested succession, and there is intestate succession. Tested succession is when the person dies with a will. Now, that will define who the heirs of the property are, who are to benefit from the property, who is to administer the property, who is to divide the property among the persons who are mentioned in that will. And then it will also mention the trustee.
Okay.
If there is no administrator, the person to whom the property is being vested, especially in a situation where the children are young, so that that trustee keeps that property, makes profit with the property for the benefit of the children.
Okay.
So the will also define the payment of debts and liabilities like taxes and monies owed in loans and to creditors.
Okay.
So that will give the person who is now passing on control over their property even after their death, so that it is administered in the manner as they would wish when they were alive. But then there is the most problematic part of the law, which unfortunately is the majority of the cases that we have today, intestate succession, where people die without a will.
Yeah.
Now, in the situation where people die without a will, then the law of succession kicks in. So it's the law of succession now, the Law of Succession Act, that that takes precedence over what is to happen to the property of the deceased.
Okay.
And sometimes some things may not happen according to how the deceased would have wished them to be.
Absolutely, sure.
For example, if a person was to die intestate, or let's say the person died with a will, and part of the will is declared invalid. So this person has died either partial or total intestacy.
Okay.
So then the court would appoint an administrator, and it would give orders as to how the property is to be divided. Now, if the person was in a monogamous marriage, that is, the person had one spouse, the spouse gains a life interest on the property. And the spouse also gets all the household and personal goods. For example, furniture, utensils,
Sure.
all the personal and household goods within the matrimonial home and the personal effects of the deceased, they go to the spouse. And by spouse, I mean a legally married spouse.
Of course.
Because we have people who cohabit. You know, they don't go through the procedures under the Marriage Act of validating a marriage to ensure that the marriage is marriage under the law.
Yeah. Okay.
So a person who has been cohabiting with the deceased under the law of succession cannot be considered as a
That's why
spouse.
so many people go wrong, actually, because
Yes.
now they feel like they needed something, and there's no evidence of you guys actually being together.
Exactly. There might even be evidence that you were together.
Okay.
For
yeah,
example,
but
there might be a
legally
child.
binding. Yeah, sure.
But do you know the child will inherit the property of the deceased, but the spouse would not.
Okay.
The unmarried partner would
Yeah.
not.
Yeah.
So it's important that people are honest also and revealing about the number of children they have,
Yeah.
the number
yeah.
of spouses that they have, and ensure that their marriage is legally
Okay.
and proper before the law.
Okay. Now, let's talk about acceptance also, because acceptance is something that many people have been trying to avoid, with the fact that now you just talked about openness. Now, polygamous setups, we have polygamous setups out here, where now that's where the problem comes in. So how do you maneuver through accepting the polygamous setup now, trying to divide it into equal portions of maybe the ratios and everything? Sometimes even ratios, as much as there's acceptance, but ratios kind of bring problems. Yeah.
The law of succession is very clear, and it predicted that such a thing would happen, because as of the time when the law of succession was coming into force, most marriages were under the African traditional law, which allowed polygamous marriages. Now, between Section 32 and Section 42 of the Law of Succession Act, it gives provisions of what is to happen in a polygamous marriage. If the deceased dies and leaves a certain number of spouses, what happens is the personal effects, personal property of the deceased will be divided among the spouses or among the houses depending on the number of children.
Wow, okay.
Now, if the deceased had a wife who was yet to have a child, that wife would be counted as a child.
Okay.
And therefore would not receive the household and personal effects of the deceased, but instead would be entitled to the rest of the property.
Sure, sure.
So upon payment of the liabilities, the loans and the taxes and other things, the net estate that remains, the property that remains that was acquired, is divided among the children.
Okay.
The law is silent on whether it should be divided equally among the children or, you know, among only the sons.
Yeah.
The law is also silent about married daughters and unmarried daughters.
Sure.
But what has been seen is that wherever there is a gap in the law, that the role of judges is to fill that gap through decisions made in the court, precedents.
Okay.
So you find decisions are made in the court that form part of the law, because based on a particular decision, other judges would decide based on that decision. So what happens in this case and what has been happening, the precedent in Kenya today as it is that for property that is subject to customary law, that is the land of my forefathers, or that which the deceased inherited from the forefathers, it may not, and mostly in the African society, it may not be divided among the daughters. Because in this case, the African customary law is given precedence over the law of succession.
Okay.
But where there is acquired property, you know, somebody was hardworking, a civil servant, acquired loans, invested, has property in a particular company, has this, has that. That one would be divided according to the Constitution, which under Article 27 gives the right of access to property without discrimination. So it will be divided equally among the children, whether married, whether unmarried, whether son or whether daughter. The Constitution does not discriminate on the gender of the child.
All right. Now, women are now being allowed to be part of the inheritance scenario in this situation, because now African society, again, it's been like locking women from so many things, but now we're getting a situation where now women are allowed to inherit. which is not something very common in our setup. Now, do you think this also will spark some debate? Because men out here, yes, they've been inheriting this, and you're used to maybe our sisters or mothers, they go and get married somewhere else. They can't inherit what it's in their home. Now, this transition, do you think it's kind of a wake-up call that indeed now men and women, we are all equal in all modern societal kind of a setup? What do you think about it?
The society as it is now has changed, and the woman is given more recognition within the society. You'd realize that previously in the past, even women used to own property through their husbands.
Sure.
And there was even a time long ago in the past when only men had ID cards, and women were identified by the men who are their fathers or who are their husbands. But times have changed. Women are educated now. Women are allowed to own a bank account, to own property in their own name. In fact, it has not changed to the disadvantage of men so much, because even a man who the wife passes on and becomes a widower is entitled to the property of the spouse.
It's true that.
So I think what people need to do with this age of enlightenment is that let people seek to invest and acquire property without really minding who it will pass on to. And when that time comes, when they have passed on, whether it passes on to a spouse, whether it passes on to children, you see, these children had something going on in their lives. It's not like they were sitting and waiting for that which they will inherit.
Absolutely.
So I think most problems of inheritance that we have today is just out of greed.
Out of greed.
Out of
That's
greed.
it. Okay.
Yes.
Now, you see proportions. For example, firstborn, secondborn, thirdborn child who is a daughter, that situation, the proportions. I know a will is very important for someone now to kind of lay out the proportion which you want actually, when you go, you want to be divided, because even in HR process, you have to be given this form to fill, beneficiaries and everything. Let's now talk proportions, because now this is where it becomes very difficult. Mzee has maybe built some buildings in town, and you feel like some 3 kids should take the first 3 floors, the firstborn can take the lower 6 floors. Now that's kind of, you know what I mean? Yeah. What do you think about that? Should it be settled out of court, maybe some agreement, because there's no will in this situation now?
Where there's no will, in a case where there is a will, and the deceased has divided the property according to particular proportions, that property will be administered according to the will. Unless a particular person who feels disadvantaged by the will moves to court to say this will is discriminatory against me.
But the writer is already gone. Can he or she maybe kind of try and convince the court to change this will?
We say the will is ambulatory. The will survives the deceased.
But I feel
as long as the will is present, the will speaks for the deceased. What is in the will is what the deceased
So it's not final.
Wanted. It's not final. Because if a person who feels disadvantaged by the will were to move to court and say, I feel disadvantaged by this will, it is discriminatory against me because I'm getting the lesser proportion, I'm getting this, I'm getting that, the court might be persuaded. Because remember, there is an international covenant on against all acts of discrimination. We have all laws against discrimination. The Constitution itself is built on the spirit that all persons are equal before the law. So on the basis of the principle of equal protection before the law, the court will invalidate either the whole will or part of the will. So then, if they invalidate the whole will, then intestate succession takes place. If they invalidate part of the will, that part which has become invalid, the provisions of intestacy will apply. So what a person says about the proportions of what you will get when the person passes on is not the last word. If you feel disadvantaged or discriminated by the will of the deceased, you could move to court and have it nullified.
Okay. Now, in a case whereby we've had traditional setups whereby even the brothers, for example, the brothers want also to be involved, not the nuclear families, the brothers that is, want to be involved in kind of taking a share of what you had. Is it still allowed? Because now we find the extended family coming so hard even to the widow in this situation. Like it's very unfortunate where you're still mourning, but distant relatives in terms of your in-laws are on your neck trying to now justify that maybe parcel A, B, C, D belonged to this side, so please. That's the coming after the mzee has passed on.
Yes.
Yeah.
When it comes to the law of succession, if there is a will, the person drafting the will can give certain property even to his houseboy who took care of him or her during the last times of the death when the person felt neglected. I mean, in a will, property can be vested even to non-blood relatives, even to distant relatives, unless a person were to go before the court and complain. But where there is no will, intestate succession only deals with blood relatives who have a direct blood link with the deceased. That means the children and the spouse because of marriage. Where there are no children, then the other relatives who are not blood relatives, such as uncles, aunts, the mother, you know, the grandchildren, that is where there are no children, they can come and claim a part of the deceased estate and they would get. Why? Because the surviving spouse is only entitled to 20% of the estate and the personal effects of the deceased. So the other 80% can go to the other relatives where there are no children. However, relatives who have no direct link, some such as in-laws, for example, distant cousins who are not related by blood are related by marriage. Persons who have no direct link cannot persuade the court to be included in the administration of the deceased of the estate. So the Bible says people die for lack of knowledge. And most people in the village and in local settlements are having this problem because they failed to seek knowledge. And knowledge is free. If somebody were to go to the office of the Attorney General, say, where is the office of the public trustee, walk in and say, well, I would like to understand how the estate of the deceased would be, you'll get good advice for free. But people neglect seeking knowledge and instead they subject themselves to being mistreated by persons who are not even close to the deceased.
Thank you so much, Bwana Baso Murara. Of course, you're a lawyer. Good job you're doing. As a young man, you're inspiring so many budding lawyers out here. Very knowledgeable. Good job you're doing. And let's hope maybe the insanity about inheritance will be solved soon, because now there's so many cases going around. And thank you so much for actually giving us your sentiments. All right, that's all we had for you right here on Morning Live. My name is Nick Mudimba. Have yourself a beautiful day. Joyce Omondi Wahiga is coming up next with Full Circle. Stay tuned to Switch TV.